Welcome back from the lunch break. This panel is really, taking the focus of solutions to SLAPPS and looking particularly at what are the practical steps that media and publishers should take to push back against SLAPPS. And as such, we're extremely lucky to have an excellent lineup of professionals and experts who've all experienced. They've been on the thin edge of SLAPPS in the UK. Just by way of introduction, my name is Sarah Clarke, and I lead Article 19 Europe. And today we're joined by Arabella Pike, who is the publishing director at Williams Collins Books. We have online Alexander Papachristou, who is the executive director at the Vance Centre. Hi, Alex. And we have Annalie Ostend, who's a journalist with Realtid, who are being slapped here in London, about which you'll hear more. And then Juliette Oliver, who's also on the panel, is the General Counsel at the Solicitors Regulatory Authority. And it's very exciting to have the SRA here after yesterday's very interesting warning notice. So we're going to hear more about that. Finally, we have my dear colleague, Flutura Kusari, from the European Centre of Press and Media Freedom, to talk about the practical fund to support journalists facing SLAPPS across Europe. So to kick off, Arabella, as publisher of Catherine Belton, Putin's People, you have really been through an extraordinary challenge over the last number of years. I wonder, from the publisher's perspective, if you could talk us through the case and the lessons learned in terms of what both publishers and the media reporting on that case could have done better, or what you felt to be very effective.
Yeah, well, I'll try my best. We're on a panel with lots of people whose name begins with A. Yeah. I have two slapped authors whose names begin with B, Burgess and Belton. Catherine Belton's case I will focus on in this session. It was called the defamation case of the century. We published Putin's People first in March 2020, just as COVID was shutting down the world. The book was very quickly greeted as the definitive work on Putin's Russia. She'd spent over 8 years researching the book when she was FT bureau chief in Moscow, and then completing it as a writer in London. It is based on unbelievable amounts of research with everybody who knows anything at all about Putin's rise from KGB colonel in Dresden through to the Putin we see today. And greeted, as I say, it quickly became a bestseller. It was an incredibly important publication. Very quickly, we were hit with a letter by Roman Abramovich, who had already given responses in the right of reply exercise to the allegations made against him in the book, and those responses were faithfully recorded in the book. It was another much discussion yesterday about these private and confidential, not for publication, righteous indignation, lengthy letters from his lawyers Harbottle and Lewis. Those letters continued for a number of weeks after publication, and then stopped. The last one said, see you in court, and then absolute silence. And the summer continued. We then went on to publish Tom Burgess's Kleptopia, which was a whole different story of SLAPPS in September. And it all seemed to be well on Catherine Belton's front. In January 2021, you will all remember, I'm sure, that Alexei Navalny had returned to Russia and released on YouTube his film about Putin's alleged $1 billion Black Sea palace. The book was viewed millions of times all around the world pretty instantly. During the course of that film, he holds up Catherine's book and says, Russian people, or words to this effect, Russian people, your future and your country is being stolen from you. This is how Putin and his cronies are doing it. Read this book. Now, we can't know this for sure, but it is our belief that that enraged somebody in the Kremlin to such an extent that the oligarchs close to Putin were then told or encouraged to take legal action. The timing of these suits, which came from 5 oligarchs, including Rosneft, the gas champion, are indicative of some kind of coordination in our belief. We can't prove that, but that's our belief. So this flurry of writs all happened just as we came to the very, very end of the 12-month limitation period before March 2021. And then, of course, the whole SLAPP experience began. And we were very, very ably defended, by Catherine's extraordinary recall, the depths of her research, what she had that wasn't in the book that could have been, that we were very much weighing up as we chose to of our strategy towards these suits. And on it went through the summer. We had the meaning hearing in July, which basically some of the smaller suits had been settled by then. There was a data protection suit from the Alpha Bank people and various other things, which we'd resolved by then. So we were left at the meaning hearing with about 26 claims for defamation lodged by Abramovich and 4 by Rosneft. And Rosneft, as I'm sure you all know, is run by a man called Igor Sechin, who is a very old comrade of Putin from all the days when he was deputy mayor in St. Petersburg. Igor Sechin plays a big part in Catherine's book. Igor Sechin did not sue us. Rosneft sued us. The meaning hearing was lengthy. We had extraordinary representation, both in terms of our in-house legal team, our solicitors and the barristers acting for us. The array of white shoe lawyers against us on the other side was, everyone out of central casting was there. One of the sort of the main points I wanted to make in this session is, I think one of the things we could have done better. And I think in terms of the legalities and the pre-publication process that we put in place before the book was published, I frankly can't fault what we did. And, the cases made against the book were so exaggerated and preposterous and, arguably not defamatory at all in the main. But we get to the meaning hearing. Abramovich, I think it was 26 suits for defamation. Most of them were thrown out by the judge, but 9 remained. Rosneft, which in some ways was the more serious case, although didn't have the headline attraction of Abramovich being attached to it, was 3 out of their 4 were thrown out completely by the meaning hearing and considered not defamatory at all. And the 4th was considered so historic as to the company being having a very tough job to prove financial harm by the cause of it. So that was a complete and utter win. The difficulty, I think, came, the meaning hearing had a packed press gallery. Everybody wanted to hear in court what Abramovich was claiming, what we were saying. That was very widely reported. And there were a mixture of some sports journalists, some legal journalists, some crime journalists. Almost no one understood the purpose of a meaning hearing. Everybody seemed to think it was the trial itself. So there was an enormous amount of what I consider misreporting on the back of the meaning hearing. And I think there is a grave need for much greater awareness and education of the defamation process amongst our media. So that upset me, it upset Catherine. And, as you all know, shutting the stable door after the horse is bolted is quite a tricky thing to do. We learnt from that. And so actually when we did come to reach an agreement with Abramovich. We were much better prepared. But he was allowed, using the platform he had with Chelsea Football Club, enormous reach into all elements of the media and society, to spin an extremely inaccurate portrayal of actually what happened. I am still asked in various interviews that, didn't Abramovich win? Well, no, Abramovich did not win. The vast majority, at least 2/3 of the claims he made against the book, were thrown out absolutely immediately, and the remaining claims, as I said, were fantastically exaggerated. So we ended up arguing about whether or not he was in a corrupt relationship with Putin or under the control of Putin. He obviously denied both, and then a few months after we settled, crops up as a peace broker reporting back to Putin when he's invaded Ukraine. So, which is it, Mr. Abramovich? I think we could have really learnt a lot there. He had a PR person there. We touched on this yesterday about the role of intelligence services and PRs in this battle. The Chelsea Football Club PR is famously aggressive, threatening legal action to journalists who won't change their stories once they're posted online. With that level of aggression and resource, bearing in mind this was before Abramovich was sanctioned, people are wary about changing their stories. The case ended well. Abramovich approached us after the judge ruled on meaning, not the other way round. We made one factual change in a case that cost us, to get to this point, over £1.5 million. And the factual change we made was that we said in the book that Sibneft, his first oil company, bought when he was about 27 years old, was done jointly with Boris Berezovsky. He disputes this, and we changed that in the book to be that he bought Sibneft with the political patronage of Boris Berezovsky. And for that factual error, we issued an apology and agreed to pay a donation to charity. It was to a charity of our choice, not his, and that was spun into a win for Abramovich, whereas in fact the majority of the case was adding additional denials to claims in the book which already included his denials, because Catherine, being the responsible journalist that she is, had extensive conversations with his then spokesman John Mann and recorded Abramovich's responses very faithfully. One interesting factor is that John Mann, his spokesman for years and years and years, was subsequently moved on to a different position in Abramovich's organisation as a part of this. So I don't know quite what that all tells you, other than the idea that this wasn't a SLAPP is for the birds. It fits every single definition of the Ministry of Justice identificatory definitions for what makes up a SLAPP. It certainly was. The exaggerated claims made were preposterous. He also sued us in Australia, so had we lost in London, we'd have had double jeopardy and had to fight the case again in Australia, where the legal system is even less favourable to defendants and pro-claimants. There is, I think, a strong case that the law at the moment is putting journalists on trial. It's the only, I'm no lawyer, so forgive me to the lawyers in the room, but to me, I can't think of another law really where it's the defendant who's put on trial and is considered guilty before proven innocent. And that has to change because this is undermining investigative journalism in this country. There is so much to investigate in this country, and we need more writers like Catherine Belton, not less. And I know from anecdotally from publishing that a lot of publishers won't go near books of this nature. And listening to Marion Jones this morning about the Jimmy Savile case, was absolutely horrifying to me. And for that man to have been shielded partly through the use of English law is absolutely horrendous. So things need to change.
Thanks, Arabella. And I think just on the role of publishers, I think you have become really quite legendary, I think, amongst many of us in this anti-SLAPP movement as a publisher who so ferociously stood by your authors. It's not something we always see, and I think that the difference in whether or not a journalist or other watchdog is afforded that support is crucial.
Yes, very much so. I mean, I'm very lucky. Again, this came out yesterday. I work for HarperCollins. We're a very well-resourced publishing company, and we don't suffer the same level of anxiety that some smaller magazines and publishers do. But nevertheless, I don't wish a SLAPP case on anyone.
No. And maybe on that note, we might go over to Annalie, who's hopefully online.
Hello.
Hi, Annalie.
Can you see me? Can you see and hear me?
We can.
Okay.
Annalie, thanks so much for joining us. So Annalie and her colleague Per are journalists at the Swedish outlet Realtid, and they are currently before the UK courts for an article that they wrote. And Annalie, I wonder if you could talk about your experience as a Swedish language journalist being sued here in the UK.
So thank you so much for inviting me. And I can say that SLAPP in UK is devastating for journalists in other countries as well. I'm going to make a long story short. This has been 2 years, and I will put it into 5 minutes and tell you about when I got sued, which I still am. I'm still sued. Many NGOs call it SLAPP, but if I say I got SLAPP, the claimant might use that in court against us. They might find that defamatory. So my name is Annelie Östlund. I'm a Swedish freelance financial journalist. 2 years ago, me and my colleague Per started to investigate the solar energy company Eco Energy World. According to a press release, the company planned to list a subsidiary on the Norwegian stock market and at the same time make share issues and bond issues at a total value of 6 billion Swedish crowns. Parallel to this, we saw that different companies in Sweden were marketing shares in the parent company, Eco Energy World, and it was promised that the parent company was going to get listed in a different country on a different stock exchange. And this didn't make sense to us. So we started to look into this company and the history of the founder, Mr. Svante Kumlin. Quite early on, we emailed a question battery of 14 questions to Mr. Kumlin, and he answered by saying that his lawyers would take it from here. The day after we got the first email, but definitely not the last, from his lawyers in London, TLT, they explained that Mr. Kumlin had no intention of responding to our questions. They also requested that we desist from contacting Mr. Kumlin directly again. They made it very clear that their client would not hesitate from suing us if we published what they perceived as defamatory statements. They also explained that their client, the Swedish citizen Mr. Kumlin, was a resident of Monaco, and that we should be aware that defamation is a criminal offense in Monaco, and that we all could be liable for a prosecution in Monaco. So this was a really scary response to our question battery to Mr. Kumlin. The newspaper we worked for, Realtid, is a very small publication. It has extremely limited financial resources. And at that time, we didn't see how we could afford to defend ourselves in court if Mr. Cumlin chose to make his threats a reality. We had literally no money. At the same time, we considered our investigation very solid. We had loads of documents and still have that prove our findings. Therefore, we couldn't just back down. So we decided to start publishing. And we published in total 8 articles in Swedish about this Swedish businessman to an audience of Swedish readers. Shortly afterwards, me, my co-writer Per, the publication Realtid and its editor-in-chief Camilla got sued, not in Sweden, but in London. And the amount claimed by the claimants was £13 million. I have heard that this is the biggest damages claim since 2004, but I wouldn't bet my head on it. Anyhow, 2 years later, the process is still ongoing, and so far we have been able to defend ourselves thanks to the organization Index on Censorship, our lawyers at RPC, and our barristers Greg Kellis and Ben Gallup. In May this year, the High Court decided to throw out large parts of the libel case against us after a jurisdiction hearing, but the founder Svante Cumlin was able to proceed with the case on 3 of the 8 articles he sued over. And this he has done. So now we are preparing for a full defense in court, which is extremely expensive. I can't go into how we succeed in dealing with the legal costs, as our lawyers advise us not to. I am always happy to defend my articles, but when it takes millions and millions in legal fees and years to do it, it becomes a big, big problem. Thank you so much for listening.
Thank you, Annalie, and I think thank you for showing us.
Yes.
I think again for highlighting the severity of these cross-border claims and how what happens here in the UK and hopefully the legal reform that happens here has such a huge impact for journalists overseas, and that this really is a kind of a global problem. The implications of UK libel, of English and Welsh libel law. I wanted to turn now to Alexander Papachristou. So Alex is the director of the Vance Centre, and Alex, we're really excited to hear. We heard last night from Paul Radu about some very exciting new developments in the pushback against SLAPPS and the practical steps that you guys are engaging in. So over to you.
Thank you very much. Just confirm, please, that you can hear me.
Yes.
Well enough?
Yeah, all good.
Yes? Okay. Well, and if I could ask whoever's controlling this to minimize my image. I'm seeing only myself, and I'd prefer to see everyone else, not myself, especially given the way I look. So thank you very much for including me in this session. Isn't that better? I am a New York lawyer, not an English or Welsh lawyer, but I have helped many clients over the last years deal with threats and claims of defamation in the English courts. These are usually non-English media organizations, usually nonprofit organizations that are scraping by to produce important investigative work. I can say confidently that all of the threats and claims were SLAPPS. None really had any basis in law to proceed. And none has succeeded in a judgment or a settlement in favor of the claimants. At the same time, I have worked with the same and other clients in similar cases in Switzerland, Cyprus, the United States, and threats in Germany and France. And so have a picture of how defamation threats to publishers compare across the globe, really. And I've participated in the EU anti-SLAPP working group, as well as meeting with the UK anti-SLAPP coalition. I commend its efforts, including the organization of this conference. And I'm particularly pleased to meet Juliet Oliver, albeit virtually, because I think her agency has begun to play a great role with yesterday's announcement and could play an even greater role. Just to be practical for a few seconds about some observations and recommendations, and then talk about the big to which Sarah referred. We've heard often, and I see regularly, concerns by journalists about the threats from lawyers. And let's get to the bottom of it. Subjects of investigative reporting use their lawyers, and their lawyers use various techniques to prevent journalists or authors from getting the necessary response, the necessary comment from the subjects of their reporting, so that they can pursue a public interest defense under English law, for example, or so that they simply can be professional journalists who want to include the views of the subjects of their reporting. And we've heard about this from Annalie right now, how her claimant hid behind his lawyers, and we see that all the time. And I have sought advice from a really eminent English lawyer who said that all of these demands in these letters, not for publication, privileged, confidential, really don't usually amount to anything at all except hot air. That only if the questions being asked call for legitimately confidential information, such as medical information, can a lawyer assert confidentiality. Privilege is something that comes about if there are negotiations between parties, which are privileged to protect those negotiations. But in the absence of negotiations, that assertion of privilege is hot air. I think it would be a great service from the SRA, if I may, with all respect, suggest that there be a clear, strong statement of when solicitors can use these techniques as means of protecting their clients, preventing journalists from doing their work, and frankly, scaring journalists a lot. I tell journalists, my understanding is you don't have to answer this letter by 5 p.m. next Thursday, as it says, that's a made-up deadline. But the journalists take it seriously. And so the lawyers exploit the ignorance and fear that journalists and publishers have. So that's a bit of practical advice. But let me talk just for a few minutes about this wonderful development. So with our key client, the Organized Crime and Corruption Reporting Project, whose co-founder, co-executive director, Paul Radu, you heard yesterday, we are establishing effectively a defense fund for publishers in the public interest to cover legal costs just about anywhere in the world to defend against defamation and similar claims, such as invasion of privacy or data protection. Only in countries where there really is no legal system that you can hang a barrister's wig on, will there not be coverage. Where the courts really are just not independent, and we know which countries those are, will there not be protection for journalists. Early next year, we will launch a new organization with the brand name Reporters Shield. We have generous support from the US government, from USAID, and also from Craig Newmark's philanthropies so far. And we hope to have more charitable support. What does that money do? Setting up this new program isn't that expensive. We do have to hire some people, but it's to create a reserve which will resemble very much an insurance company. And in fact, we're using a nonprofit insurance model from the state of Vermont here in the United States. And we will be fully licensed to perform these activities. So any media organization, or frankly, any reporting organization, a human rights organization, an environmental organization, will be able to become a participant in this program. There will be a fee, an annual fee. And again, you can think of it as similar to an insurance premium. It will be affordable. It will be reasonable. That's very much part of this. This whole operation will itself operate on a strictly nonprofit basis. And the mission will be to provide these benefits to media and reporting organizations. When a participant in the program gets a threat or a claim in a court, just about anywhere in the world, that organization will come to Reporter Shield, present that threat or claim. Reporter Shield will find a lawyer qualified to address that threat or defend that claim, contract with that lawyer, supervise that lawyer, and pay that lawyer. So the participant in the program, the publisher, and this can be a for-profit, a nonprofit, a tiny or a huge organization, will not have to pay to defend against a threat or a claim. Up to a certain limit, of course, because the whole program has to be sustainable, but a meaningful limit that will provide protection in almost all cases. One thing to note, this program will not pay a judgment. It will not pay for liability of one of its participants. And that's for a couple of reasons. We don't want the moral hazard of an oligarch knowing that a publisher has coverage for liability, suing just to get at that money. Also, the task of assessing the risk of this overall program from one or a few outlying judgments of huge proportions, millions of pounds or Australian dollars or US dollars, would make managing this program, of course, quite difficult. But at the heart of it, this program will provide Anna Lee and Per and Arabella, as if she wishes, with coverage of the defense against these claims. Now, Arabella probably already has good insurance. HarperCollins does, right? But HarperCollins still might want to participate in this program. Why? Because her insurance company would really appreciate having some help with covering her claims. And this is going to be much more affordable than the other one, I'm pretty sure. And so even a publisher with insurance might well want to buy this as well, or have this coverage as well for the defense, and leave the existing insurance for any possible liability. So this is going to, in fact, to strengthen the insurance market, not pose a threat to insurance companies at all, and provide publishers, journalists, reporters with the cost to defend themselves against legal claims. So, who's ready to sign up?
The Reporters Shield. Thank you, Alex. Reporters Shield, you heard it here first, perhaps. It is just like an initial response on that, Alex, is the number of outlets that we have spoken to in the last number of years who actually can't get insurance because of SLAPPS, and that's across many EU countries. So I know that this is going to be a big help to those types of outlets. I wanted now just to move over to Juliet Oliver, who's General Counsel of the SRA. Juliet, we're so thrilled to have you, and the timing could not be better. And I wonder if you could talk us through the SRA's warning notice, the new the notice published yesterday, and also, just as this is really looking at solutions, how you would advise journalists and other individuals who may be facing the SLAPP on sort of how they would engage with the SRA.
Sure. So shall I just give a little bit of a run through, I guess, about who we are and sort of what we've done in this area, and pick up those points perhaps. So for people who don't know, the SRA is the regulator of solicitors and around 10,000 law firms in England and Wales. So our role, amongst other things, is to set the standards for solicitors and firms to meet, and to take disciplinary action where they fall short of those standards. So that means doing things like putting conditions on their practicing certificates to restrict the way they can practice, issuing rebukes or fines up to a certain level, or prosecuting before the solicitor's disciplinary tribunal, who can strike off a solicitor from the role or issue unlimited fines. I'd like to say it's an absolute privilege to be here today and to hear and learn from the really important experiences of my fellow panelists. And I think one of the things that has struck me from what I've heard and what really jumps out to me is the importance of talking about the issues and behaviours highlighted in SLAPPS cases. And for obvious reasons, these can involve quite legalistic tactics, technically complex matters, which can be quite hard to penetrate, not just for non-lawyers. And they're often dealt with under the veil of secrecy and outside the courts, as we know. Often matters can happen sort of before you get to court processes. So awareness is key, and both amongst the legal community, so that they understand the problem and the risks that certain clients or instructions present, and can really think about what they should and shouldn't do. And amongst those who might be at the receiving end of abusive behaviours, so they can identify them and call them out. So what are we doing about this at the SRA? What we've done? Well, you'll be aware that at the start of the year, there was a real spike in the public debate about the role of lawyers acting for oligarchs following the Russian invasion of Ukraine. And there were questions raised in particular around the use of SLAPPS. And in response, back in March, we issued guidance specifically referring to SLAPPS, which clarified our expectations around how solicitors should conduct themselves when they are conducting disputes, engaged in litigation and pre-litigation activities. And that guidance didn't set out new rules, but what it does is it reminds solicitors and firms of a fundamental point, which is that they must not act as a hired gun for their client no matter what. Coming back to one of the points that Alex was making about lawyers acting on clients' instructions. What we say, and the key ethical principles that we've actually long required solicitors and firms to meet, these include obligations to promote the public interest and the rule of law, to safeguard the independence and the integrity of the legal profession. And what we say is that where there's a conflict, those principles that further the public interest prevail over the principle to act in the best interests of your client. And I think that's a really kind of important point and important basis for our ethical principles that really runs through the whole concept of SLAPPS. So with that in mind, what our guidance back in March did is it clarified the conduct which we said would attract regulatory sanction when you're dealing with disputes. So that includes making wholly unfounded claims or threatening inflated cost consequences over and above what could ever realistically be recovered. Using legal processes for improper purposes, such as making allegations without merit, where the sole purpose is to stifle public discourse. or using litigation tactics which have the aim of driving up costs, hindering processes, or intimidating an opponent. Anecdotally, our view is that the guidance we published back then served a purpose in increasing debate, raising awareness in the profession about what a SLAPP is. And we know that many firms have really welcomed the clarity of the message that we put out there around the need to have that public interest firmly in mind. And we have seen some reports to us as a result, with people raising concerns about abusive litigation. So I thought you might be interested to know we have a dedicated team to handle these cases now, and we've opened 29 investigations so far. They relate to 17 firms, all relate to defamation or potential defamation proceedings. And 14 of those were a result of a report in. The rest are down to our use of intelligence. So we've been working with organisations like the Foreign Policy Centre and the Coalition Against SLAPPS in Europe, as well as gathering information through from reports in the media or parliamentary debates. And from the work we've done and what we've seen, as you mentioned, hot off the press, yesterday we followed up our guidance with a publication of a warning notice specifically on SLAPPS. So that helps to highlight the red flags for firms to look out for, so that they can identify when they might be asked to bring a SLAPP. They can avoid acting on problematic instructions in the first place. So it highlights things like, the need to look at the target, the nature, the public interest nature of the publication that the claim is being brought in relation to, the context, chiefly reputation management, firms being instructed in that context, and things like the client asking that the claim is targeted against individuals where there might be other corporate organisations as defendants, or where this might be being brought against in multiple jurisdictions or multiple causes of action, that idea of kind of layering multiple claims. Mm-hmm. And the warning notice also highlights things that would be improper, such as bringing a claim in defamation where you're aware that the alleged defamatory statements are true, or where there's an insufficient connection with the jurisdiction, bringing a claim in the English and Welsh courts when there isn't that sort of connection there. Or, and back to the point that Alex was making, using misleading labels in correspondence, such as private and confidential or without prejudice, when those aren't appropriate, or their meaning or the consequences of using them aren't properly explained. Alongside the warning notice, we published a companion piece, which is guidance to help people on the receiving end to identify the types of behaviours that we can take action on. And it tries to help by highlighting how to make a report to us. There are some details in that guidance around who you can contact. But also it specifically flags up that people might wish to speak to us confidentially, and also to contact us to talk through what they feel able to share. And if they have that conversation with us, we can also talk through how we might be able to use our powers to access and compel information that we can use, because we recognise that people can feel very anxious about the repercussions from speaking to us and from sharing information with us. So actually what we would encourage, and what that guidance does, is say, you can give us a call, we can talk things through, and you can do that on a confidential basis in the first instance, and we can talk you through how that might, what we might be able to do and how that might sort of progress. Just on the warning notice and the guidance, I would really like to thank Susan Coftree and others who I know are here today, because we've had a lot of assistance and help and feedback on those documents, and they've really helped us to finalise those. So, as I said, those pieces are really an attempt to reflect what we've heard so far. But we also want to understand more. So what we're doing at the moment is a thematic review to explore how well the risk of abusive litigation techniques are understood, how they're identified and prevented by firms. So what's actually happening kind of under the bonnet in firms. And we've been visiting a sample of 25 firms which act for both claimants and defendants, chiefly in reputation management in that kind of area. Speaking with the person with overall responsibility for that area of work, and reviewing a sample of files that we've So we select a sort of sample of their files. And the aim is really for this to help us to identify any themes or risks that we should be aware of. It will help us to plan what further work we need to do in this area. And we also want to try and identify good practice. So where we see firms are doing good things, so we can reflect that back out and we can kind of raise awareness of what firms should be doing to help remain kind of compliant in this area. And we're going to publish the results of that when they're ready, which will be sometime in the new year. So finally, for me, I just also wanted to mention we're continuing to work with the Ministry of Justice. I think it's been widely known that we responded to their call for evidence in May, and that we supported changes to legislation to really focus on that early identification of a SLAPP and early strikeout. But our engagement with them predated that call for evidence, and it carries on. We're currently discussing with them some work to encourage the judiciary to report concerns to us. So when they see solicitors and firms coming before them, to make sure they understand what we can do and that they're referring those to us. And we've also raised with government our aim to be given statutory designation under the Public Interest Disclosure Act. So that we think might encourage reporting of SLAPPs, because it will really help employees of firms that we regulate. So where they see their firm doing things that they shouldn't, it would give them enhanced employment rights if they disclose wrongdoing to us. So it would add us into that sort of whistleblower protection legislation. So there's a lot of work in hand, a lot more to do, I know, but I'll stop there and happy to take any questions.
Thank you very much. I think just from I work a lot with the Coalition Against SLAPPs in Europe, so we look at this from a Council of Europe perspective, and I just wanted to really welcome we haven't seen anything like the warning notice anywhere else in Europe yet, so I know it's something that we were thinking is a great precedent to set. And also we've had a lot of engagement from the Consultative Council of European Judges and other judicial bodies who are very interested in exactly this type of guidance on how law firms across Europe are working. So just to say thank you very much for kind of leading on this. I think it'll have ramifications hopefully here, but also beyond. So thanks so much. And we're going to open the floor to comments and questions now, but the first intervention is actually from Flutura, who is on Zoom. So Flutura, we wanted to just kind of finish, and I think this mirrors well what Alex was telling us about with the Reporters' Shield. But with ECPMF's own legal aid for journalists in and across Europe and indeed the UK.
Thank you, Sarah. First and foremost, it's really a pleasure to be part of this panel. Fascinating stories, sad but very interesting, and also to hear about different initiatives that Alex and also Juliet shared. I think the initiative of the Solicitors Authority, it's an inspiration for all other authorities in other countries, and I think in the upcoming work with the case and other organizations, we'll use this as an example to basically push other authorities to react. With regard to the support that offers, so the EMF runs a legal support program, which is basically part of a large package of services which are organized media freedom rapid response. This is a project run by ECPMF together with Article 19, obesity, IPI, EFJ, and FPU, and what we offer various services to before I speak of the support program, very briefly on other support as well as the of SLAPPS. You hear me? I see Sarah.
Yeah, you're breaking up a little, and just seeing if we could we try your connection again for a sec? If you
yes, let's try.
Would you even turn off your video? Would that help? I don't know. Okay.
Can you hear me now? Is it better?
if you go ahead.
Test, test, test.
Yeah,
Is it better?
we can hear you. Yeah.
Okay, so I'll continue. Give me a sign if the connection is not good, then just let me know. Okay, so first, the most important aspect for us is documentation of SLAPPS. This was already mentioned in this panel and in the previous panels. And one of the difficulties that we have in documenting legal actions against journalists, including SLAPPS, is the hesitation of journalists to go public and speak about those cases. Now, sometimes it's because of the fears that something might happen to journalists, or they might have consequences in court. Sometimes it's also because they get some legal advice with which I disagree from lawyers who tend to advise journalists not to go public. Sometimes it's because some lawyers like to take control over cases. Sometimes they fear that there might be some consequences. But we've seen in most of the cases that we supported that speaking publicly, of course, with a language that it's carefully, planned, etc., helps because ultimately it's very important for journalists to be supported publicly, to have other colleagues and organizations to show solidarity, and we are unable to do this if journalists don't speak up publicly about the cases that they are facing. And then we also organize a lot of advocacy. So when journalists speak publicly, then we organize advocacy, which comes in various forms, usually with public letters showing support for them, and sometimes also with private letters. We engage with claimants directly, so depending on the case. And then is the legal support program or fund that we have. So this is a fund that provides financial support for lawyers' fees to journalists, bloggers, media outlets, whistleblowers, which are facing legal actions. Mainly, these are cases of defamation, copyright, GDPR, privacy claims, and most recently, a lot of SLAPP cases. We have decided to consider SLAPP cases as a matter of priority for ECPMF and MFR because of the increasing number of SLAPPs. So as soon as we receive a request from journalists facing SLAPPs, then we would consider that as a top priority. Now, from the case, so far we started the legal fund in 2016, and so far we've supported 250 cases across Europe. And from the cases that we've supported, we believe that London is the most expensive country to litigate. Of course, we don't have scientific data about this, but I'm basing this observation on the cases that we have supported so far. And now, of course, it's very difficult to support cases in London because of because they are very expensive. This is why we join forces with other organizations which are doing absolutely amazing work in supporting journalists, which is the Media Defense, Free Press Unlimited, and Rory Peck Trust. And so, in cases when, let's say, there are legal actions in London, we would merge funds so that we provided a higher amount of financial support, but we also collaborate a lot in vetting the cases. Now, for us, the most complex part of the cases is to vet the cases, meaning to verify facts, check with lawyers, check with our legal journalist association and unions in different countries. And so far, because of the good connections and collaboration we have with partners everywhere, we're kind of, so it's becoming easier to go through this vetting process. However, we have identified cases when some lawyers in some countries, they're trying to make a business out of it, meaning that when there is a high-profile case, they would go to a journalist, offer pro bono services, and then eventually ask for money. This is a very limited number of lawyers. We've identified them, and we make sure that first share this information with all our partners, and we don't collaborate with such lawyers. Lastly, I would say that, of course, we've supported 250 cases. The budget available is increasing. We will continue to do this, but I don't think any civil society organization can replace the responsibility of the state to provide legal assistance. There is no money in the world that can support all journalists when they need legal assistance. And I think this is why the recommendation of the European Commission on anti-SLAPP should be taken very seriously by member states, that they need to organize and coordinate legal assistance for journalists. And also to mention, this is what I was thinking when Arabella was speaking. Now, before, our top priority were cases of journalists being sued for their reports in media outlets. And now there is a tendency, we see this very often in UK, for journalists being sued when they publish books, which means within our remit, we've expanded our remit, and we also provide support to journalists when this is possible, who are sued because of their journalistic work, but which ended with a book or a longer publication. And yeah, I conclude here my intervention. Thank you.
Thank you. So we have a couple of questions from the audience, with gentleman at the back, and then Mark here at the front.
Thanks very much. Yeah, I work for Open Democracy. So, Juliet, it's great to have you here, and I've been following what the SRA have been up to, and yesterday's warning notice was of particular interest. So, since we're all friends in here, I'll give you a sneak preview of a story we're hoping to run on Open Democracy. And this was because part of my job is to look at the issue of SLAPPS. So I wanted to look at some of the law firms that have been referenced as potential guilty parties in relation to SLAPPS in Parliament. And so I offered all of these firms a chance to respond to what had been said about them under parliamentary privilege and check some other facts. So one of the firms has replied with a not for publication private and confidential letter. So I find that interesting given what you published yesterday. Any thoughts on that?
You wouldn't be surprised to hear me say that clearly I can't and shouldn't talk about an individual case on a panel, but you know, what we've said about the use of that labelling yesterday hopefully will be useful and informative for firms when they're involved in this area. And if you do have any individual issues of concern, then we can talk about it after the session.
It's very, very diplomatically put.
Mark Stevens, co-chair of the International Bar Association Human Rights Institute. Perhaps a slightly shorter intervention. Obviously, the SRA has got its act together and is taking this very seriously. One of the concerns we have is around displacement, in the sense that the clients go to jurisdictions where this isn't the same. And we note that the laggards at the Bar Council are not in the same place as you. And I wondered if there's any practical solution, particularly given the advent of the European Union legislation on SLAPPS, to coordinate with other regulators.
I think that's a very good point. I mean, I absolutely think that you know, collaboration and communication is really kind of key across organisations. I know that the MOJ has obviously been doing a lot of work, and we've been working with them, and they have a remit which is much wider, of course, than ours, which is solicitors and law firms. But it's really important that we keep on having that conversation. Can't speak for what other organisations might say, but I absolutely take the point. We have been trying to consult and engage as widely as possible, particularly as we're developing our position and doing the work such as we have recently in the warning notice and the guidance, and talking about the issues that we see, particularly encouraging people to report or trying to understand the barriers to reporting, and we'll continue to do so. But I think that's a point very well made, which is, we don't want there to be a sort of regulatory maze or a sort of sense of people forum shopping, and the more that we can do to try and make sure there's a consistent approach, the better.
Yes.
Sibyl Raphael, Legal Director at Protect. Just to make the point first that Alexander's wonderful insurance scheme is great for publishers and journalists, but of course it doesn't help the source, the whistleblower. And as Juliette, you touched upon that for you, the internal whistleblower is key to sort of discover wrongdoing, deter wrongdoing, and actually realize what's happening within law firms. It's particularly difficult for in-house lawyer to know when they can blow the whistle safely. PIDA does give them some rights, but actually the issue of legal privilege makes it a complete minefield. So this is a plea. Could please the SRA produce a helpful guidance for those in-house lawyers, also those in-house compliance officer, for whom it's actually difficult and properly dangerous to report wrongdoing within their own organization. We know, because they call our free legal advice line, we don't offer, we don't have the resources to offer representation. So we would totally support legal aid being, reinstituted for in whistleblowing cases. But that's my my plea, Juliette.
Well, there's a couple of things in that which I think are really interesting and useful to hear. I mean, I think first of all, on the point about privilege, I think it's a really important issue, and one of the reasons why in our guidance we ask people to, if they feel they've got concerns and they're not sure what they can do and they can share, is to speak to us, because when we use our statutory powers to compel information to be provided to us, so we can issue a notice, and a law firm or solicitor has to provide information to us. The courts have confirmed that means we can use legally privileged information for our proceedings. But talking that through with somebody to understand the situation they're in, or what they might feel they want to share, or what they might feel constrained about, would be really useful in any individual case. I think the point you make about in-house solicitors and in-house lawyers is also really important. So particularly for people who are in a law firm context, all solicitors and law firms have an obligation to report to us when they see a serious breach of our codes or our principles. And we do say that it's actually misconduct in itself if they suffer adverse treatment for doing so. So, the idea is that we can really kind of make sure that individuals within a law firm, if they feel they need to speak out, don't suffer adverse treatment or get sort of harmed, in their career. We want to shore up the position, and the request to be added into PIDA is something we think will be really important to kind of to help to shore that position up. But as you say, in-house lawyers might be in a slightly different position, and they're dealing with organisations that we don't regulate. We have been doing quite a lot of work recently looking at some of the risks and issues and challenges for the in-house community more broadly. I mentioned the thematic review we're doing on the SLAPPS cases. We've actually just completed a thematic review on the in-house community, and out of the back of that, we're planning to help to produce resources and guidance and material that really help in-house lawyers when they are when they are sort of facing ethical challenges and having some of the difficulties like the ones you've described. That work is in train, and it'd be really good to, maybe we can kind of catch up after the session, hear a little bit more about what you're hearing, because I want to make sure that we can address these kinds of issues through that work. The aim is to try and provide some more helpful materials and resources and practical tips for people when they're in that situation.
Thanks very much. So we just have time for one more, and we've our colleague from Chatham House and Claire. I'll take the two together.
Thank you. James Nixie, Chatham House. Yeah. Two very quick practical questions. One for Alexander on Reporter Shield. Could I just ask, what's your timeline for it coming online? And could I make a slightly selfish plea for it to be extended to not just to reporters and newspapers, but actually to think tanks as well? So just a practical question. And then on the SRA, equally practical question. What is the timeline also that one could reasonably expect between a complaint being sent in to you and a response of some kind?
So, do you want Alex first, or shall I?
Oh, either is fine. I might just take Claire's question as well. We'll just group them together and then answer them all, and then we'll neatly tie up in about
Yeah,
a couple.
yes, it's sorry, it is another one for you. Yeah, I'm interested to know whether in your your overview and your warning note, you're looking at the spread of activities, accountability, really, and transparency for these various law firms who seem to be branching beyond their professional services, for which they are privileged in many ways, and we understand that. But for firms that are also providing a reputation management service, channeling funds from their clients into PR and then on. How much accountability, how much transparency is expected on that? And as a codicil to that, are you looking at requirements for due diligence on where that money's coming from? I've dealt with absolutely, established major international thieves who have used law firms to fund millions and millions of dollars worth of PR and associated activities that one can't know the full extent of, but people like me do suspect that that's the source of the money, of harassment against us. So how what accountability is expected in this field where you have a law firm that is really, as one MP called it, a one-stop shop for services for oligarchs?
Thank you, Claire. So Juliet, are you happy to kick off?
Yes. So the timelines for cases and what one can expect. So we have some general sort of KPIs, key performance indicators, a kind of standard length the case might take. I think it's true to say that it does depend on the kind of complexities and the issues that we need to deal with. But one thing I would say is that what you can expect is that you'd be kept updated as we go through the stages of the process, so that you'll understand kind of where we're at and what might be happening next. I mentioned earlier that with serious cases which might have consequences, that for example, a solicitor being struck off the roll or a very, very high fine, that would be a case that we prosecute before the Solicitors Disciplinary Tribunal. So we'd complete our investigation, and then we'd actually issue proceedings before the tribunal, and it would go through a process then where there'd be some case management and the tribunal hearing. I think we aim to complete, and my operational colleagues will be very cross with me that I can't remember off the top of my head exactly what they are, but we aim to complete the vast majority of cases within a year. But as I say, what you could expect is that we'd be kind of keeping you updated as to where we've reached in the stages of our process. In terms of your question about accountability and source of funds and the way in which sort of firms operate, I think it's a really interesting question. I suppose the first thing I would say is, in terms of a one-stop shop, if you are a body that is regulated by us, if you're regulated to produce solicitor services, most law firms fall within a particular sort of statutory authorization scheme. Then there are limits on what you can provide in terms of sort of allied professional services, but actually, reputation management might well go hand in hand with legal services. So there are some rules around that, but particularly if you are, and we know there are also other kinds of bodies called licensed bodies, so there's different kinds of legislation where you can, a business can offer a variety of different services alongside each other. So the idea of a one-stop shop per se is not something that is necessarily problematic from a regulatory point of view, but we do require information and accountability for what firms are providing. We, before a firm is authorized, will get information about their business model, about the different services they're providing, and we require annual information returns, or returns when they change materially the way in which they're practicing. So that is information that they need to account to us for, if that answers that part of your question. And in terms of where funds are coming from, I mean, as you may well know, there is a sort of separate regulatory and legislative scheme for which we are governed by for anti-money laundering work, and that provides that with certain kinds of services that lawyers that we regulate provide, they are required to carry out source of funds checks and source of wealth checks for clients and transactions. Litigation is not captured under the money laundering regulations. This is something that there is a debate about. There is a debate about amongst anti-money laundering supervisors and with the Treasury, who are responsible in terms of the government department for the money laundering regulations. But I think it's an interesting question. I think there are pros and cons. I think there are in terms of the evidence base for particularly money laundering, for litigation being a kind of key way in which money launderers are sort of using services. I think that's something that there are questions around. So as I say, there's sort of pros and cons to that. But that's the kind of the key requirements to carry out those kind of checks do derive from the money laundering regulations.
Juliet, and then Alex, if we could just go to you to respond on the...
I apologize for having disappeared briefly. I'm slightly amused at the question from Chatham House, which we know for your Chatham House rules prohibiting reporting on your events. But I can assure you that as a think tank reporting in the public interest, you would qualify for this program. To the extent that you are issuing reports to the public, informing them about matters of public concern, you would qualify for this program, just to give you a sense of its breadth. We hope that this program will launch in the first quarter of 2023. And we have a website coming up, I believe, soon, and it will be possible for eager participants to indicate their interest and get themselves lined up for qualification. There are some requirements. We need to weed out nefarious potential disruptants in this program. So we will have to go through a qualification process, but it won't be rigorous for real reporters, reporting organizations. Just a matter of establishing your independence and your commitment to public interest reporting, and then you will be qualified to participate in the program. It will survive and thrive if many, many people participate, many organizations participate. So not only yourselves, but those you can recommend should join. That will also, of course, make it more affordable. It will operate in some sense like an insurance company, except it won't make a profit. So every excess revenue will go to reducing the cost to the participants. So hope very much to see all of you on the roster sometime early next year. Thank you.
Thank you, Alex. And thank you to all of our panel. To Arabella, thank you for standing so firmly, and you've really given us a model of the behaviour of publishers. So huge thanks to you. To Annalie, we're with you and we're supporting you through this case. And I think there are a lot of lessons learned, as Arabella discussed, about how the media should be reporting on your case too. So I hope we can see some improvements around that. To Alex and to Juliet, thank you for these updates. It's very very inspiring to see that this is actually that the momentum is translating into practical and effective changes. So thank you for your leadership on this. And we'll close it there. And Susan, do we have any time for a break before the next panel? We do. Great. Thanks very much, guys, and have a great afternoon. Thank you.
Thank you.